Now, Kenya's new Companies Act came into force with plenty of fanfare in September, but it's now causing unease among foreign investors due to clauses which, among other things, require that 30% of any foreign firm's shares in its local establishment must be held by Kenyan nationals. Now, Kenya's Attorney General has now suspended that clause, which several legal experts have described as being impractical. Now, Mugambi Nandi is an advocate of the High Court, specializing in commercial law at Kenyan Advocates, and he's joining us now to go over some of the other contentious elements of Kenya's new Companies Act. Mugambi, great to have you on the show. Welcome. Now, the provisions that foreign investors must surrender about 30% shareholding in their business to locals or pay a fine has been one of the most hotly contested parts of the Act. In light of the pros and cons of this particular provision, what are the options in terms of amendments that can be made?
I think there's only one option, and that option is to delete that provision in its entirety, because it is not facilitative of business, and where there is need to prescribe limits for foreign investors, there are specific sector laws that do that for strategic reasons, say like in telecoms and energy, and that is where the restrictions should be, if at all.
Well, actually, the Cabinet Secretary for Industrialization and Enterprise Development in Kenya, Aden Mohammed, and of course Kenya's private sector and the legal fraternity, they actually met today to review the entire 2015 Companies Act, and of course other issues like the shareholder structure that have arisen from this act. Now, what are some of the other issues that have been raised about this act?
I did not attend the meeting today, but from the conversations that have been going on amongst lawyers and business people and investors, one of the major concerns is the cost of compliance, because the new act is voluminous, has very many new provisions, and it is going to be much more difficult to comply with it, especially because non-compliance is now going to attract penal sanctions, fines of sometimes up to several million Kenya shillings. The other thing is that the act is very long, so it like acquits itself against being read. Of course, the provision on 30% Kenyan citizens owning shares in foreign companies has been a hot one, and professional associations have also been complaining about the small companies regime and seeing that as lost business for them.
Now, still looking at the specific 30% in the Act. Now, the Parliament has actually acknowledged the contentious provision, and it actually said it will be amended in 6 months. But will we possibly see this provision being challenged in court at any point if it's not amended?
It's very unlikely that anybody would get orders in court because it's a policy matter, even though it is in the law, because it doesn't affect human rights as we know them, and especially also that it is not anti-Kenyan citizens. So even if anyone were to go to court, it's unlikely that they would get orders. But I do expect that the provision is going to be removed in due course. Typically, changes can't be made until after about 6 months of passing a law. But in this case, I see that the Speaker might use his power under the standing orders to have the changes fast-tracked.
Now, Mugambi, looking at Africa in general, in light of the situation with MTN and of course Nigerian regulators, what is your opinion on how African governments are structuring laws around foreign investors and foreign companies coming in? Do you think we can find a balance between protectionism and this open door mentality?
I think African governments are doing very badly on that front. If it's any comfort, even the developed world is also doing very badly. In fact, worse than Africa in terms of protecting their industries. The problem, as I see it, is that Africa does not encourage intra-Africa trade. In a sense, it's like African governments prefer dollars when they come from the States or from Asia and other continents. And so you find that there are a lot of barriers to business in Africa, even outside of the law. Specifically talking about laws, you have immigration laws that are not very enabling. You have licensing regimes that are cumbersome, demanding, inconveniencing. And then, of course, you have that ugly thing called corruption, which is all over Africa. And in that, that in itself is a barrier to trade.
Mm. Well, thank you so much, Mugambi, for those interesting insights. Of course, he's joining us here in Nairobi.